or Lexis to find out whether or not the court has rendered a decision on an issue. Does the website still have the local opinions, I believe? Is that correct?
Yes.
Right. The court's website has opinions from each of the judges posted on there. I'm not sure if they're indexed the same way as Lexis by topic, but they're all there.
They are, it's text searchable and it's searchable by judge, and I think that's it.
Okay.
But it is a searchable index.
But you can go in and see all of Judge Grant's opinions if you're in front of him on an issue coming up and see if he's ruled on it. So, but it takes a little more work than Lexis.
And that may also have things that Lexis and Westlaw don't have, although they tend to sweep up everything, including things we wish they wouldn't. I've had a couple scheduling orders published by Lexis, and I'm thinking, why are you wasting electrons?
What is till interest rate? What happens if the creditor doesn't think it's enough and objects to confirmation of the plan? What does the creditor have to prove to get a higher interest rate? Well, till, if anybody doesn't know, is a Supreme Court ruling on interest rates. It basically said you start your analysis with prime rate and then a risk factor of 1 to 3%. So today the prime's what, 3 1/4?
Right, 3.25.
So you'd be looking at maybe anywhere from 4 1/4 to 6 1/4, depending on the riskiness of the asset. Second part of that is, I'm not sure if they're asking how do you get to the higher end of the range or how do you get higher than that. I don't know that you get higher than that.
I don't know that you can get.
See, I read till a little differently. And remember, till was a 4-1-4 decision. It just so happened that it came out of a court that followed, at the time, the step approach. If you remember, pre-till, there were about 4 different approaches towards calculating interest. You had the cost of funds approach, which was, well, whatever it costs the creditor to borrow the money, they're going to do it that way. There was a Fed funds approach, so that the debtor got it at the same rate the federal government got it. There was a prime plus, and then there was market, where you had to come in and prove what rate would be available in the open market. And you had 4 people, I think, came down in favor of market. And you had 4 people over here, and then you had 1 in the middle that said, well, I think it's different, but the rate that I would do is higher than what we've got, is lower than what we've got. So they ended up affirming this step approach. But if you actually put all the decisions together, it's an endorsement of a market approach towards interest with the presumption that prime is the appropriate rate. And the burden is on the party that wants to move it up or down, could go down, could go up, to prove that in the open market, a higher rate or a lower rate would be called for given the nature of the loan, and you can balance risk and reward and the security of how payments are being made. But it was very interesting. One of the things I found most interesting is the 4 that took the lower rate adopted their market approach and came up with 2.6% number out of the air. The 4 that went the other way adopted a market approach and came up with 22.6%. And so you've got the guy in the middle that says, I think prime. And so since 5 of us think that the rate should be higher than it, or should be lower than it actually is, then we're going to affirm. And so that's the origin for the thinking that till ensconced a step prime plus type of regime when it really didn't. But what do you need to prove as a creditor to raise the rate? You probably can't afford it. In terms of evidence and experts and investment bankers, I mean, just think what it takes in Chapter 11 to prove the appropriate rate of interest for the shopping mall. It's a lot. Same concept in 13, just smaller value.
For those people who are going to be coming to Lafayette who aren't used to my office yet, as you just heard Judge Grant say, it's TIL plus, prime plus. That means that to the extent that you offer a car credit or 7%, 6%, 5%, we will object, because I believe you start at TIL at 3.25, and then the creditor has the duty to come in and prove it's higher. So I think people in South Bend and Fort Wayne are used to that, but if you're an attorney that practices in Lafayette, just please realize that when you see those plans.
That segues really well into our next question, which is what changes can we expect in Lafayette? Besides that, Ms. Miller, as you take over, I assume, Judge Grant, you're going to do things pretty much the same, just Mr. Rosenthal gone?
I'm constant.
Okay. So, Ms. Miller.
I'm not nearly as funny as Dave. I don't answer my own office phone. I do not arrange to get appliances for my debtors. Generally, I think that Dave and I, procedurally, and our views are pretty much the same. I mean, we both practice in front of Judge Grant, so, I mean, we're pretty much the same there. The only two differences that I can think of off the top of my head is, number one, my 341s are done by Zoom. We expect video and phone, and we expect you to send a copy of your license and the Social Security card for the debtor before the hearing. Well, I guess there's three. Number two is our office believes you are required to use the national plan. If you file anything other than the national plan or you attempt to modify it in any way, we may lose at the bankruptcy court level, and you may get the ability to go up and do an appeal. Number three, we do allow TFS, which is a trustee payment system. It's where the debtor can actually go online, set up payments to make their bankruptcy payment. Other than that, we'll be doing amended wage orders. Your clients have all been notified by Trustee Rosenthal that we are the new trustee. We'll be sending out stickers, and I really don't see much difference other than those three things.
All right, here's a question. This is one I've had recently. Is a house that has been quitclaimed to another person 5 years prior to the bankruptcy while retaining the life estate by the grantor, is that still an asset of the debtor? I would say it's an asset of the debtor and the estate. 541 is pretty broad. And if you want to know how to value it, I typically have used the IRS. There's tables that you can get. You can get them online, and they vary based on, you know, the age of the person. So you need to know the age of the life of the life tenant. But it's sellable, and I think you can sell. Since you can sell a co-owner's interest, I would think you could use that to sell the entirety and then just take the percentage for the estate. So anybody see anything different?
And I think, too, if one of the things, at least I think both Paul and I are going to ask is, why did it get transferred? Tell us why. Because if it was to avoid a creditor, that's not going to bode well.
Anything else, Judge?
I would second the comment that Ms. Miller made, because 5 years was an interesting number, because if memory serves me, Indiana fraudulent conveyance window is 6 years.
Right.
So even though 548 limits you to 2, the trustee has that perfect lien creditor who could bring any action that might have been brought by creditors, can take advantage of state law fraudulent conveyance, avoid the transfer, and sell the whole, keeping the proceeds of the whole, not just dividing up life interest and the remainder interest.
And I think we have to find a creditor that was a creditor at that time to use that, as I recall, to use the state law, if we go back to that period. I think that was one of the requirements.
That
I think,
may very well be.
yeah,
I would have to.
IRS is always a good creditor to use.
yeah, yeah. Iris. All right. Well, Judge Grant checks that. Here's one. If there is no equity in a house, that is, the mortgage exceeds the fair market value, can the debtor still claim an exemption for purposes of avoiding a judgment lien? I think that's pretty much how you have to do it, right? You got to claim it, and you file your motion to avoid, and even if there's not really any equity, you need to be able to avoid it. So, okay.
There's nothing in Indiana law or bankruptcy law that says there's got to be equity in property in order to claim an exemption in it. And absent lien avoidance type issues, you may be wasting your limited exemptions, but.
Okay, let's see. Oh, here. Given the pandemic and all the changes, what is the view of DocuSign to sign petitions? Homes are purchased and billion-dollar deals are signed electronically. Why not consumer bankruptcy lawyers? We see hundreds of people a month. I think there's an oath on there, as I recall.
Yeah, there is.
It says you've signed it. I don't know if that works with DocuSign, but it seems to say you signed it.
It's interesting because this is actually something that the Federal Rules Committee is actually talking about, is whether or not you have to have a, quote, wet signature, which means the debtor taking a pen and actually signing it, or if an electronic signature is sufficient. And I think if I remember right, just from our conversations, the wet signature is still required by the federal bankruptcy rules. So to the extent that you think that DocuSign is sufficient, I would suggest you write to the Federal Rules Committee and explain why you think it's sufficient, and then it's something that we would take up at a later date. But right now, I don't think that the courts actually...
Remember, there are different standards for what constitutes a signature. Ms. Miller's right. The only documents where we require a wet signature, so to speak, an original signature, are documents that are filed under penalties of perjury for that oath.
Attestation.
Under non-bankruptcy law, to sign a document is any mark, in essence, that you choose to use in order to demonstrate your assent. And that can be an X, an electronic stamp, a weird symbol formerly known as Prince.
Paw print? Yeah.
It can be about anything. So there are different legal requirements or legal standards by which signatures are judged, and what is a signature can be judged.
This one was directed to Judge Grant. Some credit counseling agencies have been filing the debtor's certification for the debtor counseling course with just a debtor's electronic signature. Is this sufficient? I didn't know the debtors signed them.
I didn't either.
I don't think they
Is that,
do sign
is
them.
that maybe the credit counseling agency's electronic signature intended? I don't know. So,
Yeah, again, Rules Committee actually just took this up. Why are we getting all Rules Committee stuff? Anyway, the change is actually going to be that the post-credit counseling agency is going to have to actually file the certification from now on instead of the debtor filing the certification. It used to be that there was a national form that the debtor would put the certificate number on, and then they would fill out it all, and then they would sign it, and then they would upload it to court. So the change in the rule is going to be the credit counseling should file it, and to the extent that the credit counselor does not file it, then the debtor attorney or debtor can file the certificate of counseling, not the form. So there is no signature by the debtor on the certificate of counseling. Jerry?
Yeah, I a supplementary document that the debtor would sign, but they got rid of that several years ago, even in Indianapolis. But I do recall in the past, we had to submit like rule form F-423
Right.
or something that stated that the debtor had to supplementary sign, but even there they got rid of that. But that might explain the.
Yeah, the form that needs to be filed is the one with the barcode at the top right. You've all seen those? And the reason that that form has to be filed is because we have had so many of them counterfeited and altered. And if you file the form like Jerry was talking about, we can't tell that they're altered. So that's why the rule's changing, and that's what you're going to need to have you, your client, or the counseling agency file.
Okay, this one has two questions. One of them was about COVID relief. I think that got covered in the mortgage panel. Hopefully that was clear. It was about the extension of the CARES Act, so I think that was covered. Here's the other one. Can a mortgage be discharged in a Chapter 13? I think the answer is depends. If it's property's being abandoned, it can be. If it's being stripped and paid in some lower amount, if it's eligible for that, it could be. If you're paying it long-term and carrying the default, it's not, I guess, right?
Now, remember, we're talking about the debtor's personal liability, not the lien itself.
Yeah, yeah. But if you abandon it, you don't want to have a deficiency, sure, I think it can be discharged, yeah. Okay, let me move on here. I got some more. The Chapter 13 case was dismissed prior to confirmation.
Oh, no.
How do I get my attorney's fees? Do I get the full amount debtor agreed to pay me for the bankruptcy? If not, what do I have to file or prove? Stay tuned.
I can't answer that because I'm in litigation.
You're in litigation on it?
I'm on litigation,
Okay.
so sorry.
We won't put you in a spot.
And one of you can't either. So I think we need to skip that question.
Yeah, I mean, you file your application, and we may object, and there may be a hearing about it, I guess is the short
File
answer.
the application and see if there's any objection there too, which there more often than not is no objection.
Yeah. And if,
But
you know,
that's the answer, do you get the full amount? No.
I'm willing to read the order dismissing the case because there's nothing strange there. At least our orders say case dismissed. Any entity that wants to file an application for administrative expenses has 14 days to do so. Beyond that, I'll just make people mad.
yeah. Well, yeah, there's,
Okay, can I ask a question?
Sure.
If it-
Answer's not guaranteed.
If a case is converted, can they file for fees? Supreme Court says.
Pre-post confirmation.
I don't think it
I'm-
matters.
I don't think it matters.
Pre-confirmation, yeah, because that's what the statute says. You return the money to the debtor after deducting any administrative expenses.
Okay.
Post-confirmation, yep. Supreme Court, I think, has said something different.
Yeah, they just said give it all back.
Yeah, Supreme Court
Period.
said.
But as a practical matter, post-confirmation, the case is getting dismissed, you don't have any money left. So it's a moot issue.
That's probably true at that point, yeah. This, I think, is, all right. What should be included in a pretrial order? Is there an example of a good pretrial order that you could suggest or that we could use as a model? And we talked about this a little bit over lunch. We're actually going to, I think, offer this as a topic next year. We thought that would be a really good topic and have some sample forms and input from the judges on what they want. And but we can probably give the real short version of it, I guess.
Our local rules provide what should be in a pretrial order. So you can look at our local rules and see all the points you need to hit. Having said that, though, there are some occasions when I've had a particularly difficult case or they were about to try, and I've required much more than that, and I have given them a sample and said, I would like you to do this because And if you get that from me, it probably means you not talking, so I'm going to try to force you to talk to resolve your stipulated evidence, the duplicative documents that you keep bringing up in all of these different issues, and to streamline your issues so we know exactly what we're talking about and surprise arguments don't come up during the trial. So yes, I do have a simple version and a little harder version. But oftentimes the harder version gets people to the conclusion without a trial.
So now you want us to talk to each other and read the local rules.
Dang.
Wow.
We're not going to have time to do anything else.
Yeah.
It's Local Rule 7016-1C, and there are 10 different things that we ask you to put there. And if you at least want to know more, once again, I will refer you to answers to frequently asked questions concerning practice in front of Judge Grant, because what do you want in a pretrial order is part of it, complete with some citations to situations in which the pretrial order didn't measure up. And there, because I'm not going to approve anything that you submit as and remember, it's got to be joint. You've got to get together. I don't require you to agree on the outcome of a dispute. You're free to litigate, but I do expect you to agree as to what you're fighting about. And if you don't, it's a very painful experience for all of us.
It has, and I have kicked trial dates over when the parties have brought everybody in and they're ready to try the case and they didn't submit the pretrial order, or it was woefully deficient. And then clients don't like it, witnesses don't like it, but I have had to come out and say, we're not having a trial today.
And maybe one of the differences in procedure from Hammond to Fort Wayne is if we want a pretrial order, I will not schedule a trial until it is in and approved, as opposed to schedule a trial and give me a pretrial order 7 days ahead of time.
Right.
Because I've had too many situations in which I don't have a pretrial order, and now I'm on the horns of a dilemma of wasting a half a day of trial or whatever. Or let's go ahead without it, and you go ahead without it, and you find out that they're talking past one another, and it's worse than listening to a 5-year-old learn how to play the violin.
And so next year we'll try to have some of those in the materials, some samples, so you have them in the meantime. Rule 7016 of the local rules, right? Okay, here's an interesting one. The trustee objected to my proof of claim and it was disallowed. As claims are allowed unless objected to, can I just file another proof of claim? That strikes me as a bit problematic. Anybody want to take a shot? Yeah, this is a proof of claim was disallowed. Since a claim is otherwise allowed unless objected to, can I just file another one? And that one's allowed until objected to.
Res judicata is an affirmative defense. So you can file your claim and it will be deemed allowed unless objected to. But if somebody comes in and objects and says the claim was denied, then game over. You can't just respond by filing an amended claim. Furthermore, and this is what I think is intriguing, in the Seventh Circuit in bankruptcy, and I want to say it may be Taxman Clothing, in evaluating the filer's duties under Rule 11, and this was dealing with a trustee seeking to avoid preferential transfers. The circuit held that the filer's duty under Rule 11 includes not only investigating the merits of the claim, but also any, quote, obvious affirmative defenses. So by filing a motion, a pleading, a claim, which is obviously not allowable for various and sundry reasons, including res judicata because it was denied, or, as I have held, because it's obviously barred by the statute of limitations. Nothing has happened on this thing for the last 14 years. That may be a violation of Rule 11, subjecting the filer, be it an attorney or a client, or a creditor to sanctions. So it's best not to try to play games with the system.
Now, here's an interesting one. How does the trustee determine which creditors get paid in a confirmed case each month? I use a roulette wheel with names on it. What's your system?
That sounds good. I like that. I think we pretty much do it the same.
Okay, yeah.
Well, the first thing that's always paid is the ongoing mortgage payment. We're going to catch up the ongoing mortgage payment.
Yep.
And then we're going to catch up the car payment.
Yep.
And then after that, I usually pay something to attorney's fees.
Try to give them a little something.
And then I pay the mortgage arrearage as a secured claim, and any other secured claims like tax claims, anything
Yep.
that's getting interest. When secured claims are paid, we pay priority.
Yep.
And after the priority and the secured, like the mortgage arrearage and things like that are paid in full, then we pay unsecured.
Exactly the same in our office, yep. So, yeah, and then we have some guidance in our confirmation order on how those fees are paid out as well. So, but with that little change, I think we're exactly the same there. So, what does the term vesting mean? If the property is vested back in the debtor at confirmation, this might take an hour. Does that mean a debtor can A, sell the property without permission or notification to the trustee or court? B, is the automatic stay also lifted on that property? Anybody want to take a shot? We're down to about 2 minutes. I don't know if we can do this topic justice.
The quick answer to the question is vesting means the donning of a small sleeveless garment. The more complicated answer is we don't know. There is precious little case law out there in an overall capacity talking about what vesting means. And there are at least 5, maybe 6 different approaches to vesting that run the gamut from the bankruptcy estate disappears to it doesn't mean much of anything at all, and everything in between, some of which actually contravene provisions of the bankruptcy code, such as Section 348. The Seventh Circuit has never directly ruled on the issue. They've got a couple of decisions, such as we talked about today, where they talk about vesting and maybe consequences, but they never address an overarching theme. And to come up with what you think they may be thinking, you kind of have to read between the lines and backwards. And it's not at all clear. And I don't think it will be for a long, long time. It's like a jigsaw puzzle with 50 pieces missing.
One of the reasons that our office requires vesting in the estate until discharge or dismissal is because when we litigate any sort of mortgage issue, that is always the first thing that they bring up is, does the trustee have the standing to litigate this issue? And there's case law that says that if the real estate is no longer vested in the estate, the trustee does not have the ability to litigate that. So if you're wondering if it's so mishy-washy, kind of weird out there, why are we doing that? It's because the litigation that we've done, that's been the first thing brought up every single time. And we don't want to have to deal with it. We don't think you guys should have to deal with it. And it clears our way to go ahead and do the litigation.
We're going to do one more. We're really out of time, but we got 4 or 5 we're not going to get to. But this one comes up so much all the time. It's an unwritten rule that every Chapter 13 debtor must total at least 1 car during the pendency of his case. That's true. Actually, I think it's written in our office. The question is...
Usually on the way to the 341 meeting.
Yeah. Who gets the insurance proceeds? Okay. Well, you start out as cash collateral, so if there's a lien, they're in line first, no question about it. One of the interesting things that's happened to the car market is they've gotten more valuable instead of less valuable because of the inability of manufacturers to make new cars. Right. I've even had surpluses sent from cars that were surrendered when they were taken to the auction. I've never had that until this year. I've had 2 in 2 weeks. I mean, people should have sold the car, I guess. They had some money, they could have exempted it. But anyway, I think secured claim, clearly it's cash collateral. I don't think there's any doubt about that. Then what happens to the rest of it? I look at the exemption next to the debtor claim, $700 of exemption in that car. I think maybe they get the $700. And after that, I'm sort of taking a position, I think it probably should go to the creditors. Yeah, might need to modify the plan. It's not necessarily provided for, but it's kind of, it's either some sort of a asset with excess value or income or something that sounds like it ought to come into the plan to me. And I'm not articulating that well, but that's kind of the position I take.
One of the problems that we run into is liens attached to proceeds until dismissal or discharge. So even though you may have crammed that car down and the secured value is less, or you have crammed that interest rate down, that creditor still has a lien on the full amount of that insurance proceeds. And it used to be that we didn't get contacted by the insurance company about that. But now there's certain creditors who will call us and say, we know you have an extra $4,000 and we expect you, to send it to us. And we're like, no, you're not actually entitled to that because you're in this pool of unsecured creditors. So when somebody objects, what we're doing is we're holding those funds then till the last disbursement, and then whatever should go to unsecureds actually goes to all unsecureds instead of just the car.
Yeah, we do the same thing. That is the fourth category, is that sometimes we have to hold it, and it's sort of a contingent lien that springs back upon dismissal and attaches to those proceeds. So we have to be wary of those, and we do it on any case where there's a cram down.
Yeah.
So thank you all. We're out of time, and if our tax panel could come on up, we'll roll into our final session.
We'd be done.
Good job.
Yeah, thank you. You can leave mine. I'm here.
I'm sorry.
That's all right. Thank you. Yeah, Kim can come here. Have you seen Doug? Last I looked, his
Here's mine, I'm sorry, I didn't leave my trash there.
Oh, there he comes.
You may need to, who's going to run the PowerPoint?
Oh yeah. You know what? I will. I'll move down there. I'll come down here and run the PowerPoint.
I'll sit on the end, I'm shy.
All right. Let me see here. Whose is this? That's Anita's. That's Doug's. There's Anita.
I thought I had everybody's. Did
Well,
I miss somebody?
no, I think we got them. We're just moving them because I moved over here.
Can you sign in, please? It's worked. Oh, wait, I won't say that yet. I was going to say it's worked.
Yeah.
Don't forget to take your wine.
I got one.
Is this yours? Oh no, she just signed it. That's it. Oh, okay. How you doing? All right.
Who's the famous Mr. Shale? And Ms. Miller, the equally famous Ms. Miller. And whose cancer it is, can I talk to her?
Did you see Anita?
I saw her earlier.
Did she take a break?
I want to say hi.
Oop, that's the wrong one. That's
Shale,
ethics.
where would you like it?
There's one with your name on it.
Oh, okay.
Right here next to me. On
All
this.
righty. Okay. Hi, how are you?
Hey,
Good,
yeah,
Doug DeGlopper.
that's the ethics one.
Oh, hi, Kim. Nice to meet you. So nice to meet you after talking to you on the phone. over and over again. Is that Catherine there? I'm going to say hi to Catherine. Is that her right there? Oh, over there.
Should this be called tax panel? Ah, there we go. There we go.
There you go.
Thank you. We would all agree with that. Is she coming? Okay. She's coming. Huh? Oh, well. We won't let them see that. Oop, oop, oop.
Hello, hello. Hello. Hello again.
All
I
right.
got so excited I had a binder of tabs.
Oh, binder. A binder. Who would have thought? These chairs are for really short people.
I know my legs keep falling asleep. I'm trying to go around.
One of the attorneys who works for me, he's 6'4". He's been going up there and sitting because the chair's higher. Plus, he's antisocial. I gotta tell you, I don't think I've ever drank that much. I still
Dan was in bad shape this morning with me.
I've been in bad shape all day.
He started drinking vodka, and then he switched to wine at dinner. Whatever you mix, it's a problem.
Yeah, you can.
So that's why I just stick with red wine all night. I'm
Yeah.
usually pretty good. So yeah.
Oh, there you go. So I don't know if my brain's working at this point,
Yeah.
but at least remember my case. So
Well,
that's
we
all that
got
matters.
plenty of people to share the issue with.
There you go.
Okay, get your final drink or snack or whatever, and we're going to get ready to go here in just a minute. Final session, and we can get everybody out of here. We appreciate everybody's attendance today. We will plan on doing one of these next year. If you have ideas for topics you'd like to hear about, put it on your evaluation form. A reminder to complete your evaluation forms if you would. We like to know what works, what doesn't, what you like, what you don't like. Materials need work, speakers, etc. If you have comments about the facility, good or bad, add those. We like doing it here. It works well for us. But please complete the evaluation. Make sure you've signed your CLE sheet. If you want your hours, for those of you that are virtual, please remember to email me your CLE sheet with your hours you're claiming so we can get that report sent in. So with that, we're going to go ahead and start our final
How are you?
panel,
Stand, but you know how that is.
Property Taxes and Bankruptcy. And we've assembled a panel of people that have some expertise in this area that are going to share some of that with you. First, in the middle to my left, Anita Gloyeski of the Gloyeski Law Offices. To the far left, Kim Mortitis with Manning Mortitis. And to my immediate left is Doug DeGlopper. Doug, on this it's spelled wrong, but
Oh, that's
it is,
okay.
it is
I'm
a
used to
G,
it.
you know.
I'm used to it.
Don't want to have an attorney where you spelled the name wrong. Nobody can find you. So
That's good,
Doug
actually.
DeGlopper, and he's an attorney in Indianapolis, right?
Yes, sir.
So we're going to start with the very simple part of this, which is What do you do with property taxes before there's a sale in bankruptcy? And who wants to, Kim?
I would advise you to pay them.
Pay them. Well, okay, we have somebody here that represents the county treasurer, obviously. But you sort of have to for a couple of reasons. Why is that?
Well, property taxes by Indiana statute are an automatic secured lien on your property, and if you do not pay them, they will go to tax sale.
That's a good reason. And oftentimes our debtors don't get them paid. And how are those claims typically filed? Doug, you file some claims you represent the treasurer as well in some counties?
We do. I've been representing the Marion County Treasurer for about 30 years now, and we typically file our proof of claim. One of the problems we have is that if you don't list all the properties that your debtor has, it becomes problematic, excuse me, for us to file our claim. What we see a lot of times is that people may have 2 or 3 or 4, or maybe they're in the rental business and they have a bunch of properties. And if you don't list all those properties, then we can't track them to file our pre-petition proof of claim. So I know you all do, and all the debtors' attorneys make the yeoman's effort to figure out what all they own. But for us, it's really important to know at least what we own, or what property the debtor owns, rather, in the various counties. For us, it's Marion, but if they own property in, Hamilton County, or if they owned Allen County property plus Kosciuszko County, then at least the Kosciuszko County treasurer knows to file a proof of claim. So. And
if you list the wrong county for some reason, they may not know about the bankruptcy and might go ahead and try to have a sale. We've had that instance happen at least once in my office, where the wrong county was notified, and it wasn't a residence; it was like a subsequent property they owned, a lake property or something. Anita, how do you typically treat these in your plans?
I typically treat property taxes in a plan by being paid directly to the treasurer. If there's been a tax sale, I've started to learn differently through Mr. DeGopper. Sometimes you pay it directly to the tax purchaser. And I think that's a difference in districts. We've always paid them to the trustee through the trustee's office here in South Bend.
So if your debtor comes in, they're behind a year or two on their taxes, you're going to put that in the plan as a secured claim to pay, basically?
Secured claim through the plan, yes.
One little caution, sometimes people have a lot of properties. We get a lot of this in the northwest part of the state, and maybe they're going to surrender a bunch of those. And, okay, I'm going to surrender the secured claim. One little caveat there, and I'm not sure that the treasurer's always filing their claim this way, the most recent year of those taxes can be a priority claim under 507 A8B. So there could be personal liability for that prior year. It's just like an IRS or Indiana Department of Revenue priority tax liability that you have to pay even if you're going to surrender it. So be wary of that if you've got somebody that's bought a bunch of properties and can't pay the taxes and they're going to surrender them. And I get a lot of that out of the Hammond division. So,
and if I could follow up
Sure.
on that briefly, another thing we see quite often is that the debtor will propose to surrender a property or 2 or 3 or whatever, but the problem is that the surrender sometimes doesn't get accomplished very quickly. And I've seen a lot of situations where you'll try and surrender the property to the treasurer, basically. Well, obviously, we're not going to take that property back unless, we've had folks have tried to surrender properties with it. I'm sorry, we've had issues with people who have, maybe some environmental issues on their property, and they try and surrender it back to the treasurer. So it doesn't mean that it's automatically going to happen. The other problem we have is the time frame. So we will often still file the proof of claim because it takes a while after the surrender for maybe a mortgage foreclosure to finish up or what have you. So the problem is that the property is still listed in the name of the debtor, could be up to a couple of years. So sometimes we have issues there, just kind of FYI. And by the way, if I stink up here, you all have Judge Grant to blame. I was his very first law clerk. So if I'm horrible, then please blame Judge Grant, okay? Just wanted to get that out of the way. Thank you, Judge. Good to see you. Thank you.
All right,
Trustee-
let's talk about,
Trustee,
I think for the most part,
Sorry,
Go
one
ahead.
other
I'm sorry,
thing that
Kim.
I think might be helpful when we're starting out filing these proofs of claims, or if you're filing a Schedule B and putting it in your plan, when you look at the taxes online, so for example, in Lake County, you're looking at the property taxes, you can do a search right there online. Make sure you are noting in whatever you're filing with the court, the tax ID number. Because if you put an address, you may have more than one tax ID number for multiple parcels, but with the same address. So I've seen it a few times where a debtor believes they're making payments, and they are, but only on maybe the parcel that the house sits on and not their side lot or their backyard, and that can cause problems down the line.
And sometimes they may own a half of a lot next to the house, and the whole thing may be part of their mortgage, but there's still maybe two tax numbers for some reason. So you might want to spend a little time trying to make sure you've got everything listed so that the claim that gets filed and paid is all of it. So
That's another great point. I think that's a great point. Another issue sometimes that we see is that if your debtor is buying a property, for example, on a land contract, I know we talked about that, and I don't know if we'll address that later, Paul, but if your folks are buying it on land contract, the treasurer doesn't know that. Oftentimes, believe it or not, at least in Marion County, the way we find out about how to file our proofs of claim is that we'll look right in the court and commercial record, and we'll see who's filed a Chapter 7 or, well, a 13, not a 7 usually, it's a no asset. But we'll see who filed the 13s or the 11s, and then we will track that person's name and try and figure out what properties they own. So we can maybe do a little bit of that work for you. But we're never going to figure that out if the property isn't listed and it's not in their name. We just won't know, so FYI.
all right, the more, I guess, complicated and problematic area is what happens, when there's a tax sale. Prior to the bankruptcy, there's been a tax sale, and there's a couple different phases where we can have this, anywhere from right after the tax sale to a year or two later. And why is that a problem?
Well, if you file your bankruptcy, do you want me to get into the Lamont case? Is that
You
where
can
we're headed?
roll right
Yeah.
into that, yeah.
I'll kind of roll into that. How many of you have heard of or read the Lamont case, the Seventh Circuit decision? Have you? Okay. If you haven't, you might want to read it. I think it's in the materials.
It's in the materials, yes.
And a copy. I took a copy online and put it into a Word format. So if a couple of the words look funky, that's my fault. But it's pretty much word for word. It's a verbatim reprint of the In Re Lamont case. One thing that I think even Paul may not know is that the Lamont case was actually, the debtor in that case was Lamont Cranston, young wealthy man about town. Really? Not even a smile? Not even a smile. Too early? Too late?
We're brain dead.
You guys don't get that? Lamont Cranston, young man about town, the shadow? Oh boy. All right, I'll leave that one in the shadow, sorry. So anyways, Lamont was a case where it kind of, at least as far as folks like me who represent the treasurers of the world and tax sale buyers, it kind of turned things on its head a little bit. Basically, Lamont stands for the proposition that if there is a tax sale sometime before the bankruptcy filing, and there's differences of opinion in the Northern and Southern District, but since you all practice up here, it seems like in the Northern District, it seems like Judge Lindquist in another case has held that as long as you get the bankruptcy filed even the day before the expiration of the one-year redemption period, or there could be other redemption periods, be aware of that. Like, I know some counties do certificate sales, some counties do 2 successive tax sales, so they might have different redemption periods. The first tax sale might result in a 1-year redemption period, the second one may be only 90 or 120 days. So you need to be familiar with that. But Judge Lindquist has said that as long as you file that bankruptcy before the expiration of the redemption period, correct? Then you can go ahead and put the repayment of those taxes in your plan. And you can treat, the Lamont case went through a lot of machinations about what is a tax sale buyer and what kind of an interest do they have. Suffice it to say, the Lamont case decided that the tax sale buyer basically has a secured claim that can be paid through the plan. Now, poor Anita, I've already messed her up, and Ms. Miller and Ms. Iskin here, they probably both hate me as well. But there's been a difference between Northern and Southern districts about what that actually means, how you address it in the plan. Suffice it to say that as long as you've got the tax sale buyer noticed, got to get them notice. Because Lamont, they didn't notify the tax sale buyer. But Mr. Lamont, or the tax sale buyer in Lamont, didn't bring that up until it was on appeal. So he kind of basically, what's the proper legal terminology? He screwed himself, I think is the word, because he didn't bring up the lack of notice. So you really need to notify your tax sale buyer when you file your bankruptcy. And again, I realize that some of you don't even know. Debtors come in and they give you all the information and they don't even tell you, or they might not even know that their property's been sold at tax sale. But if you do know that, you need to certainly notify the tax sale buyer. So then we're to the point in Lamont where that can be treated through the plan. Lamont didn't specify how that should work mechanically, but it did say that in essence, and the reason why the tax sale buyers are irritated is that you've now stretched out that 1-year redemption period into a 3 to 5 year Chapter 13 plan. Now, I will say that Lamont was based on Illinois law, which has a 2-year or 2.5-year redemption period. But in Illinois, they have a really cool statute which allows a tax sale buyer to come in and just say, cancel the sale, give me my money back. I don't want to deal with the bankruptcy. But that's only Illinois. We don't have such a statute in Indiana yet. We're trying, but we don't have it yet in Indiana. So the tax sale buyers are pretty much stuck with whatever treatment you're going to provide through the plan. So that's basically the Lamont case.
About 20 years ago, we spent a lot of time trying to figure out when you could undo the mortgage foreclosure. What's the last point in time where you can bring the house back and save it? You know, and it's the sheriff's gavel at the sheriff's sale in Indiana. The Judge Lindquist basically said the redemption period is the equivalent of that if you have a tax sale. So when you're meeting with the debtor and they say, well, there was a tax sale, you've got to find that out. Who do you call? You call the treasurer, tax sale division? Can you find that out with a given property?
You can. Usually after the tax sale, in most counties, it's going to be the auditor. You know, the treasurer and the auditor kind of work together on tax sale matters, but once the tax sale has occurred, the auditor is going to have all that information about what it's sold for, the exact date it's sold, the expiration of the redemption period, what it would take to redeem that property. You're generally looking at the county auditor to call to get that information. And a lot of even smaller counties, they kind of have one person who kind of looks over all the tax sale stuff.
So when a debtor comes in with their well-organized papers for you as debtors of counsel, you don't seem to find that redemption notice there. That's probably the first thing you should do is call.
I usually
you want to know.
call,
You don't
yeah.
want it to be, oh, it's tomorrow. I could file it today and save it, and
Right.
I saved it till next week, and I'm too late.
Right, right.
Yeah.
I usually, especially in counties like Howard County, there's one person you call and you speak to one person, and it's always the same person, and they can always tell you what's going on.
And I suspect many of you already have that drill. You know who to talk to, but it's very important that you get that timing right. So.
And I
All
will
right.
caution everyone, if you are practicing in Lake County, there are at least 2 people you need to contact related to this, because we've got someone who is handling specifically bankruptcy cases, and then we've got someone who is handling specifically tax sale cases, and you need to make sure that they are on the same page. And just because you sent them notice does not mean that they've entered it in the computer the same way. So just touch base with everyone, make sure we're all on the same page with this.
Now, the tax sale purchasers seem to have some special issues they have to deal with timing-wise. If you're not in Illinois where they can cancel the sale, and I think there's been some of those that have sort of been done by agreement with the treasurer in Indiana, if I'm not mistaken. And I'm not sure if you were involved in one. It seemed like there's been a couple of those where they've sort of reversed it, maybe by agreement because it was a mess.
Yes, there are statutory ways to undo a tax sale, but generally it's because there's a mistake. I don't think you're going to run into a lot of those with the bankruptcy specifically. But I did bring some examples that some of you may have seen before, just so we're all on the same page with these. When you have a debtor who comes to you and they hand you something that looks like this, read it, please, because this is a tax sale certificate, and then we've got a commissioner's certificate. They look almost identical, but they are vastly different in their effect. So the easiest way to tell, if you can't tell just by glancing at it, what you have, look at the bottom, because it tells you on here when the redemption period will end. With the tax sale, so that would be the first sale, you're going to have a year. With the commissioner's certificate, you're going to have 120 days. Don't make that mistake. Also, I'm sorry, Trustee, I'll also point out on here, you will see a figure, and I find this is when I'm representing tax sale purchasers, this is where debtors are tripping up the most in their plans with the payments that we are to receive. You look up here in the corner and it says certificate value. That is not your redemption amount, especially when you've got the commissioner certificate. You're going to have the certificate value here. Below that, you are going to have the amount that this person purchased the certificate for, which will be a lesser amount. Neither of those is going to be your actual redemption amount. And we have included in the materials the redemption statutes, so you can kind of piece through those, but I always advise you to call the treasurer's office and find out what your actual redemption amount is at that time, because there is interest, costs, and other things involved.
And can we just bring up too, that redemption amount changes with time because of
Yes.
the accrual of interest. So that the redemption amount you get today is going to be different than the number you get in 2 months. So just FYI.
Absolutely, and you may have your tax sale purchaser paying some other taxes and things as they come due, and they will certify those amounts with the county. So you want to make sure you have the most updated figures, especially as you get towards the end of your plan. You don't want something to pop up at the very end there.
What does the tax sale certificate holder have to do? Leave aside the bankruptcy for a minute. What do they have to do to complete their process of owning that property if they're going to go all the way through that?
Shall I?
Go ahead, go ahead.
Generally, they need to give notice, and then they need to petition for the deed in a certain amount of time. So after the tax sale, if you don't have a bankruptcy involved, then in almost all your counties up here, I've been told, it works that it's up to the tax sale buyer to do all the work to secure the deed to the property. So we've talked about whether or not tax sale purchasers have to go ahead and get relief from stay. I think a lot of them do, just so that they can do the work necessary to get that deed, provide the notices. You know, they have to do a title search. They have to see who all might have an interest in that property, which is, you know, sometimes that'll turn up a mortgage creditor, and you might have a basis to set aside the sale then because the mortgage creditor wasn't listed in the original sale notice or whatever, so that may give you a basis to ask the auditor and the treasurer to set aside the sale. But basically, I think the safer course that a lot of tax sale purchasers have taken is to go ahead and file some kind of a motion for relief from stay just so that they can do the work necessary to secure the deed. Because remember, even if it's a 13, it may fail. So they may be, 10 months into the plan and they're still going to ask for the deed because the plan didn't go according to
Yeah, it seems pretty clear the stay would apply. I mean, the petition is to say, yeah, I want to own what was your property. There's an automatic stay in effect, stopping litigation or preventing litigation. So it seems pretty clear, but they also have some time frames they have to worry about, don't they?
They sure do. There are some limited time frames in which you have to give notice, and those are usually a certain amount of time before the expiration of the redemption period. And then after the redemption period expires, you have a certain amount of time, again, depending on whether it's a tax sale, commissioner sale, whatever, but you have a certain amount of time then to actually petition for the deed. I think we would all agree up here that perhaps the noticing might not violate the stay. Maybe we wouldn't all agree, but I personally think the noticing part of it probably doesn't violate the stay, but certainly the act of taking the deed and petitioning the county to actually issue the tax sale deed to you, I mean, I can't think of anything that would be more violative of the stay, right, Anita?
Sure.
You've actually done that before.
I've actually done that. Oh, I've had a very difficult case in Southern District. Yeah, that's in the materials that I'm not sure if we're ready to talk about that at this point or not.
I think it's a good time. We're talking about the stay and how it stops it. So why don't you go ahead and talk about
So
that real quick.
the case that I'm referring to in your packet is called ZB Stokes. And it was a Chapter 13 that we filed where my client, ZB Stokes, had a land contract with another individual that was not filed with the county. So, and we were going to pay it in full. And month 54 or so, the seller of the property filed a notice of mortgage payment change, which included taxes and insurance that were from the beginning of the bankruptcy. So we filed a motion, we objected, and we filed a motion to determine what the postposition payments were going to be paid through the seller, and came to an agreement that anything over 180 days they would not be reimbursed for. Everything was going to be paid through the trustee. My client paid it through the trustee, and about 6 months later, not even 6, a few months later, he gets a flyer brought to him by a local child. Your house is being sold. It was sold last year, and you have 1 month. So we had to file a lot of things very quickly. One of them was, it's actually in your packet. And basically, we asked for contempt because when they filed their motion to determine post-petition fees, they filed it for fees that they hadn't actually paid. And the attorney for the seller said it was all a big mistake. It was incurred because they got a bill for it, so they should be reimbursed for it. And the seller actually never took that money and paid those taxes. So he actually had been enriched and had all the money. We filed the motion, went to trial, and we didn't get a big judgment, but we got a judgment nonetheless. My client ended up getting his house, so he's a very happy man at this point. But it was a mess.
Did the attorney get paid?
I got paid, yes. Yes, it's in the decision. Will I collect? I don't know, but I'll be paid with it. But the one thing that I would probably have done differently with this plan is that.
All right, here you go.
What I would have done differently in this case is that I would have specifically said in the plan that the seller must give the bills for the taxes to my client within so many days. Because if we had done that, we could have probably avoided the tax issue. But that was overlooked.
And we get a lot of land contract
We get a lot of
cases
land
too.
contracts,
So,
too.
I mean, that's
Yeah.
a good practice pointer for everyone is find a way to get that notice and get everybody involved.
Can I throw out one more thing I think that's really important to debtors' counsel? A lot of times, this whether it's a tax sale or not, a lot of times you'll see the treasurer might not even file a proof of claim because there's no pre-petition taxes due. But post-petition starts to accrue every May and November. So as you're going through a 5-year plan, you may have already accrued. We do this quite frequently in Marion County. Not that we're cool, we're not, but we're blessed and lucky to have a lady who handles only bankruptcies for us. So she monitors all the Chapter 13s, and as they miss their post-petition tax payments while they go through the Chapter 13 process, then we will, every July when the amounts are certified, if they're three installments in arrears, we'll file a motion for relief from stay. So if you could share, one thing I haven't learned much in my life, but one thing I've learned is that if debtors' counsel can maybe share, and I'm sure you already do, but share with your clients the importance of keeping current as they go through the bankruptcy. Because I think a lot of times debtors, I've had them tell me over and over, I thought these taxes were being paid by the trustee.
All I have to pay is the trustee and life is good.
Yeah. So they don't stay current, so that becomes a big problem.
Yeah.
And if you're
Post-petition.
practicing in Southern District, Judge Carr has ruled that post-petition property taxes, you don't have to file a motion for relief from stay because the property revests back into the debtor. It doesn't revest back into the estate. So they don't have to file a motion for relief from stay in the Southern District.
So,
at least in Judge Carr's courtroom.
And we still do because we're worried, and he still tells me every time I go to court, he says, you don't have to file this motion for relief from stay. But of course, we have 3 or 4 judges down there, and they do things a little bit differently. His attitude is the tax sale buyer is just stepping into the shoes of the county at that point, and there's no violation of the automatic stay if we go ahead and offer it at a tax sale. I've always kind of had the willies about that, but I think legally, Judge Carr is Judge Carr, and he knows what he's doing, so he's told us that several times. So be aware if you ever sneak down, like I know Anita has a nice young man down there who does a lot of Southern District cases, and that could happen. You could get your property sold at tax sale post-petition, even while they're in bankruptcy. So.
Doug, you were talking about these time frames for notice and different things. What happens to the buyer if he doesn't do that? Is he still just fine? He's got his tax certificate. He's good forever?
Nope, loses out. That's why it's so important
Yeah.
for the tax sale buyers to follow these procedures, because if they don't, they lose out.
So you need to get stay relief, but the stay relief you need is to go do what the stay is trying to prohibit, which is take property from the estate.
That's correct.
And so it's not just paying a secured claim now, it's trying to do it in a fashion where the secured creditor's lien doesn't vanish.
That's correct.
Essentially.
That's correct. And that's the worry. It's funny. A lot of tax sale buyers that you talk to, they either want one of two things. I think the majority of tax sale buyers seem to want the interest factor. they're almost counting on people to go ahead and redeem the property because they want to earn that interest, because where else are you going to get 10 or 15% interest on your money anymore?
Yeah.
But there are a lot of tax sale buyers out there now, especially with all the seminars you see and whatever's going on. They actually want the property itself. So they'd like nothing more than to see the debtor fail so they can glom onto the property. So just FYI.
Kim, we've had a lot of these where we have just that situation. The tax sale certificate buyer says, that's fine, I'll take the stream of payments, but I need to be protected. And you've got a sample in the materials of an order that we've, I think, developed over time for the to allow all that to happen. You want to kind of walk through how all that works?
Absolutely, and I think this resolves a lot of problems if you can get your clients to agree to it. I've had some debtors be a bit hesitant to do it just because you are essentially putting the deed to your property in someone else's name. But what this is, and it's a boilerplate order here, so you can feel free to take it, change it, do whatever you want to do with it, but it gives you an idea of what you can do to take the county out of this equation, okay? So essentially, you're giving, as debtors counsel, relief from the stay for the tax sale purchaser to go ahead and petition for tax deed. Now, when they get that, you're essentially going to have a land contract under this agreed order with them. And it benefits your client not just because you're taking the county out of the equation and some of the issues that go along with that, which we'll talk about in a bit, but that surplus, if there's any surplus, that is still accruing interest. And that can be a significant amount depending on how much was bid at the tax sale. So that's going to go to the trustee and then back to the tax sale purchaser. So the amount that your client is essentially redeeming is vastly reduced. So that helps. And then in these, we have been agreeing to generally about 5% interest, which is less than you would otherwise pay on some of these. So does anybody have any questions on that? I know that's probably a lot to digest.
I'm sorry, I didn't hear what you said.
I said, does anyone have any questions on how that works?
Well, so it's a lot of work for our office, but we're willing to go along with it. We end up holding a deed in escrow. We end up having to coordinate and file a voucher with the county to get the surplus. I mean, there's a lot of steps involved that are not part of my normal job description, but that's the way we can make it work. So that's what we've done. And I've got a safe in my office right now, and it's got 7 or 8 envelopes in there with names of cases on them and deeds, and I'm waiting for instructions to someday deliver those. And I've done that on a couple of them already. Some of them have paid out, and I've delivered a deed. But remember that, maybe on average, half the Chapter 13 cases in the world don't make it. And the ones that don't make it, then your buyer's already has title and he's good to go.
Absolutely.
So it's kind of a creative solution to deal with that problem where just the two worlds don't fit well together.
That's right. The alternative is if your client doesn't want to do something like that, the trustee's office has been phenomenal about working with us on these, but he's going to essentially have to set aside these funds as the debtor is paying them monthly until he's got enough to send to the treasurer for redemption, because our statutes and our counties are not necessarily set up to accept periodic payments after these properties have been sold at tax sale or commissioner sale. So he's going to be holding this lump sum for a while until that goes back to the county, and that can be problematic for everybody.
Okay, we have a question back here.
Okay. Well, 2 questions. Number 1, South Bend, Fort Wayne, we do things differently than Lake County does. Anita knows that. And what we actually do, so you know, is the county actually pays off the tax sale purchaser, and then we pay the county through the plan. So just realize that if you do have a tax sale issue, it is in St. Joe County or over in here, call Catherine or I first, because we call the one person at the auditor's office to ask them how they want us to do it, and then we'll have you structure the plan accordingly. Number 2, Doug, and I dumb question. What happens to the tax sale surplus? When is there a surplus, and how do we as trustees find out about it?
Boy, what a great question. Can I give you my input real quick, and then I'll shut up? And the surplus, what happens to create a surplus is that the tax sale buyer comes to the sale, and there's a minimum bid. And oftentimes, if it's a property where there's, let's say there's only, $10,000 in property taxes owed, but there's buyers out there, excuse me, who think, boy, that's a $100,000 property. That's a nice property. Normally, you don't see many of those. A mortgage company, somebody will step in and pay the property taxes so it doesn't go to sale. But sometimes you do. So then there's a little mini bidding war. So then let's say they end up bidding it up to $60,000. Well, now you've got $10,000 that goes to pay off the back taxes, but you've got this $50,000 chunk of money in surplus. And the tax sale buyers are not too worried about that because generally speaking, absent a bankruptcy, that surplus is going to just sit there and it's going to accrue interest and they're going to get paid back the surplus with interest if there's no redemption or what have you. But it's interesting. I have had, and I've been told that there are debtors' attorneys out there and trustees, and I'm not going to name any names, who will go to the county treasurer and say, hey, pay that surplus money over to the trustee. And in certain counties, they will do it. They get a note or a letter from the Chapter 13 trustee, and I would be scared. Whenever I get something from Paul Shale, I know I'm scared. And so I do whatever he tells me to do. So a lot of treasurers have actually paid that money over. I think debtors, sometimes their debtors' counsel think, well, let's let that money sit in the trustee's account rather than let it sit with the county. I don't know what's happened up here, but down in the Southern District, we fought that battle in the Harlan case. And when I say we fought that battle, the treasurer, we stepped up and we said, wait a minute, there's only two things that trigger the distribution of the surplus. Either redemption is accomplished or the deed is actually issued. So we want that surplus to sit right there. And part of the reason why we think it's important, I'll put on my treasurer's hat for another minute, is that as that money sits in surplus, it's going to accrue interest. So we want to keep that money in surplus. But the judge down in the Southern District, at least, decided in the Harlan case that no, there's no duty for the county to turn over the surplus. In Harlan, they wanted to use the surplus to kind of pay the redemption. They thought, okay, let's get that money into the trustee and use it to pay off the redemption. But that's not really necessary. The surplus can sit where it is. So I don't know, does that answer your question at all? What happens to the surplus?
No.
Okay.
But after it's all done.
Oh, after it's all done?
Redemption, after the tax sale deed's transferred, there's a surplus.
Right. Okay.
How do Paul and I know
Oh, great question.
that surplus is there? Because it's a state property and
Right.
should be going to creditors.
Great question.
Deb, are you saying when the debtor files they don't want to redeem the property?
It could be, we've had rental properties that have actually been surrendered. We've had, you name it, we've had it happen. And Allen County, Roy, I don't know if you're here, but I still appreciate you because of everything you do with Allen County Treasurer. They'll actually call us and say, hey, we've got a surplus. This was a piece of property in bankruptcy. It's still open. Do you want it? And then we go to court and we actually prove that we're entitled to the money, and then we get the surplus and then we distribute it to creditors. But my question is, how do Paul and I know on pieces of property that have been surrendered or other things that at one time were property, they say that there is this surplus? Is there some place we can search?
Well, obviously, you'd have to call the treasurer or the auditor to figure that out. But I think I can answer your first question really directly, if I can. The trustees, I think, are in an awkward position because now the treasurer never wants to take partial payments. So you are kind enough generally to amass that amount of money and then pay it over to the treasurer in one fell swoop, correct?
Right.
So when that redemption then gets accomplished, if I could direct you to John Haber down in the Southern District, he's got a really cool little form that he files with the bankruptcy judge that just says, okay, look, the redemption has now been accomplished. Let's go ahead and release the surplus to the tax sale buyer. Because obviously if the redemption is accomplished and the debtor has kept the property, then that surplus goes back to the buyer. The other situation is if there's no redemption and the debtor gives up on the property, that surplus goes to the debtor.
But that's a state property. It's
Well,
not
that's a
the
good question,
debtors.
and that's something that, would be battled out, I guess, in the bankruptcy. But I think you'd be well within your rights then to file a motion to have the surplus turned over to the trustee, correct?
If that sale was, prior to the bankruptcy, that surplus is sitting there, that's like money in the bank to us.
Yeah.
Not quite, it's a little more work.
Especially with we know people that are actually paying so much more at the tax sales than the property is actually worth.
Sure.
So once it's all over and that surplus is still there, we don't want that money to go back to the debtor.
Right.
It's not theirs.
Yep.
Yeah.
So,
I think that's when you file your motion, right, Paul?
Well,
You
and that's
say-
why we've been getting some of those surpluses as part of this process with the agreed order. We file the voucher and get it out. Everybody agrees that it can be paid over. And that sounds like contrary to what you do down there, or what you prefer at least. But we get that in so that's not an issue. So, what's the difference between the regular tax sale and a commissioner's sale?
It's weird because different counties do things differently. So I'm so familiar with Marion County. Let me apologize. But as I understand it, in a lot of counties, and Anita, you can speak to Kokomo, Howard County, maybe even more than I can, they'll offer the property once at a tax sale, and if it doesn't sell, then it'll go to what they call a commissioner sale.
Don't they also do that if someone has purchased it at tax sale previously and they didn't pay that next year's taxes?
That's
They'll then
correct.
sell it also at commissioner sale?
That's correct. And the beauty of the commissioner sale is that it allows the county to finally get that property back on the tax rolls without collecting every drop of tax that's owed. Because think of it this way, we've got so many houses that have been condemned and knocked down in Indianapolis. There might be a $30,000 demolition lien that's now been attached as part of the tax bill. So there's 40 grand owed for back taxes on a vacant lot somewhere. Well, nobody in their right mind, although we have had people buy those. We have out-of-state pension funds come in and plunk down millions of dollars and buy up everything they can at our tax sale. But generally speaking, you're not going to do that. You're not going to pay way more than it's worth. So what happens then is it gets offered at a subsequent sale, but finally in the commissioner sale, or in Marion County, it's called a take, and there's different rules. They have to have it appraised, and they're supposed to sell it for at least the appraised value. But in general, what can happen then is we can get it back on the tax rolls for a lot less money. Now, after a commissioner sale, and Anita, please correct me where I go wrong, there's a lot shorter redemption period, correct?
Is what, 180 days?
120 days.
120-day redemption period. So if it is, so that's why you do want to know what kind of a sale was it. Was it a tax sale or was it a certificate sale, commissioner sale? They call them different things.
Yeah, we get a few of those too. We get quite a few of those in Northwest Indiana and the Hammond Division. So again, you got to know which one you're dealing with and find that redemption period, because same problem. If you're after the redemption period, according to Inri Lodig, which now has district court affirmation, you're out of luck.
Except in the Southern District, where we've had two judges opine. Judge Grant, I would love your opinion on this, although I know you can't give us advisory opinions, but we've had two judges opine down in the Southern District that as long as the deed has not been transferred, so in other words, the redemption period could expire. Now you're 6 months past the redemption period expiration date, and the deed has not been yet transferred to the tax sale buyer, you could still stick it in your plan. So that's a real interesting conundrum to me. But I don't think you had that issue up here because you've got the wonderful Judge Lindquist up here who said, that's it. The redemption period expires and you're done. You can't put it in your plan anymore. So.
That's correct. That would be the Lodig decision. We had Judge Lindquist rule on that, and he was very, very clear, and he actually attached to his decision some prior decisions, like the Weathersby decision, which are all in your materials, that in the Northern District at least, so if you're practicing with us up here in the Hammond area, if that redemption period has run, your debtor no longer has a legal right to that property. They cannot redeem. That decision by Judge Lindquist did go up to Judge Simon in the district court, and we are now up on appeal on that one. Briefs are due October and November, so if we're lucky, maybe by the end of the year, early spring, we'll have a final decision on that matter.
We talked a little bit about post-petition taxes. I think another potential option in the case, if it's brought to our attention, or maybe the creditor can do it, is dismissal under 1307C. Maybe that's cause for dismissal, not maintaining the property taxes on your property. Another potential issue, again, the debtors like the part of the automatic stay that says you don't pay anybody anymore, you just pay the trustee, and it's one nice payment, and they take that so seriously they forget to pay the taxes. Well, yeah, not all creditors are the same. It's an ongoing one, so. Stay relief, obviously, Doug talked about that being done down in the southern part. In your materials, we've got some statutes, we got the cases. I got a little summary of the cases here. Do we have other questions from the audience on this topic? Any particular problems you've run across that we haven't touched on yet? Anything else? All right, what else? Anybody have anything we didn't cover you wanted to say? No. Okay, I think we are done. We are done with the seminar. Thank you all very much for coming. Please remember to do your CLE. Thank you, panel.
Thank you.
And please grab